Hi, my name is Nick Foreste with the MMM Corporate Tech Law Practice, and I'm proud to host this presentation today with my MMM colleague, Richard Boswinkle. He's with our firm's SBA Loan Group. Today, we'll be discussing the CARES Act and the new SBA loan programs available to tech companies. We fielded a number of questions from our clients over the past couple of days and decided it would be worthwhile to consolidate some of these questions, do a quick and hopefully informative Q&A session. So, Richard, let's go ahead and dive straight into our discussion. What tech founders need to know about SBA loans under the CARES Act? All right, Richard, question number one. What companies are eligible to participate in the SBA loans made available by the federal government under the CARES Act?
Just to really answer it, payroll protection program that's in the CARES Act. There are existing SBA programs that borrowers could avail themselves to, including the Economic Injury Disaster Loan Program, existing 7A loan program, and 7A Express loan program. The latter two remain unchanged, and the Economic Injury Disaster Loan Program it's been modified somewhat to open it up to a much broader participation. When we're talking about the program that most folks want to talk about, it's this Paycheck Protection Program, a PPP for short, if I abbreviate it here. And so that is now available to groups greater than what used to be the SBA limits. The SBA traditionally has only made loans to small business organizations or small business concerns. And those are all determined by classification codes, by industry. Those are all published in federal regulations, and you can look all that up. It really goes beyond this. But the PPP program here has opened that up by expanding the size of businesses that can participate. So you can be eligible for this as long as you have 500 or less employees, or if you are in an industry in the hospitality or food services business as classified by applicable standards, you can theoretically have more, and you get classified as not having more than 500 employees at a particular location. And then there are a couple other things you can still participate if you're an independent contractor, if you're self-employed, sole practitioner, things like that. One thing to keep in mind, and there are also some limited nonprofits that can apply and be eligible here. That is a limited 501c3 companies, nonprofit corporations. We do not think it's going to apply to private clubs, 5037, country clubs, things like that. Don't think it's going to apply there. So, like everything we're about to talk about, I should also mention we're still waiting for the SBA to promulgate its regulations and give us official guidance on how this program is going to roll out.
Understood.
So that's kind of it.
Okay, perfect. Jumping to the next question here. So what are the primary differences between the Paycheck Protection Program, as you mentioned, PPP for short, and the Economic Injury Disaster Loan Program, the EIDL for short?
So there are a couple big differences. First and foremost is kind of how the programs operate. The Paycheck Protection Program is going to take the form of a forgivable loan. And if worked properly by a borrower, is really going to be essentially a grant from the federal government. So that is where the sweet spot is, that most folks will want to participate as long as they can fit within the eligibility box. The Economic Injury Disaster Loan is a program that's existed. It's been expanded, but it has existed for a long time. It is what's the same exact program that's been used for flooding, for hurricanes, disaster relief throughout the country. All those loans you apply directly through the SBA. You can get right on their website now. It's got a maximum loan amount of $2 million, but it's a real loan. So you're going to, for the most part, have to pay that back. Now, there is some mention of being able to potentially refinance those loans if they were used for the appropriate purposes using the Paycheck Protection Program. And then possibly you could get some loan forgiveness that way. But once again, we'll need to see the regulations before we can say for certain that would be available. Going back to the Paycheck Protection Program, once again, like I said, it's a forgivable loan. That's a big deal. If you don't want to take this debt on your books, that's a huge benefit. It also can be up to a maximum of $10 million for the loan. Now, that actual loan amount is going to be calculated essentially as 2.5 times your average monthly total payroll. Calculating that, there's some finesse that one has to go through as to calculating that, particularly if you're a new company. Generally the standard is looking back at your numbers from 2019, early 2019. But if you weren't in existence at that point, you actually take the first 2 months of 2020 and average those. Those are the big, the real big differences.
Okay, perfect. All right. As it relates to our practice in general, there are, a number of venture-backed clients that we work with, and they're zeroed in and have asked a number of questions on the affiliates language that's included in the program. So I guess the question for you is, what if my company, or what if the client has raised outside venture capital money from institutional investors? Are they still eligible?
So that is the big question right now. The CARES Act, which adopted this PPP program, actually accepted out healthcare and hospitality from what's called the SBA's affiliation rules. These affiliation rules are what have traditionally ruled out venture capital-backed businesses from being able to participate in SBA programs. Primarily because it requires them they treat them as affiliates, and then they're required to count all the revenue or employees of not just the company applying for the loan, but also the venture capital company and all its other portfolio companies. And so when you aggregate all those together, they tend to not qualify under the size standards, and they're no longer considered a small business concern. So traditionally, that's why they haven't been able to participate in SBA programs. Like I said, hospitality and restaurants have both been accepted out specifically in the act, and there's a lot of movement right now, a lot of lobbying going on to expand that to other venture capital-backed or private equity-backed business models. But until we get the regulations out, we really don't know.
Got it. Okay. A related question on this is what if my venture investors only hold convertible debt today, so they don't actually hold equity ownership in my company just yet?
Well, traditional SBA rules state that you look at everything on a fully diluted basis. So, convertible debt, options, warrants, et cetera, all that has to be baked in, and that becomes part of the analysis. The affiliation question is really a complicated one. You would think it's sort of an easy one as far as, okay, what's my percentage ownership on a fully diluted basis? But if you go through the guidance that the SBA provided several years ago, and honestly, they just changed it at the beginning of the year, and they rescinded it through this act because of what they're trying to do right now. The traditional look had been, okay, if you had 50% or more ownership, definitely you had control. But the SBA actually viewed it as greater than that. If they had, 2 or more groups that had, even neither one of them had 50%. Even together, they only had, say, 45%. They wouldn't technically have control of the company in a traditional standpoint, but everybody else is a really small participant, small owner. The SBA rules have deemed them to be affiliated and have, counted them in. So it's a tricky subject, not as straightforward as one would think. And that's the main reason we really want to see guidance from the SBA, and we're hoping that they will actually, accept out and give some leeway here.
Okay. All right. And I'm sure we'll be on the lookout for those updates and sending client alerts to the extent we get any of those anytime soon. Now, in the interim, what would you encourage a company to do that maybe has venture investors on the cap table who would otherwise disqualify them from being able to apply as of today? Do they start the application process, hold off? What would you recommend?
Well, there are a couple things to do. First, I don't know that there shouldn't really be any penalty for applying to one of these. Everything I've read and the lender clients I've talked to are anticipating these being as low cost, low touch, easy, quick as they can to borrowers. That was it's stated in the act that it's supposed to be that way. So, I don't think there's going to be application fees, although there may be, but there's certainly, waived. All the traditional fees that borrowers pay with SBA loans are all going to be waived pursuant to the act. So reaching out to a lender, particularly one that you've got an existing relationship with, and we may get to that in later questions, But reaching out and starting that process is probably good at this point, because at the end of the day, A, we need the guidance from the SBA, and B, you need a lender to interpret and understand and decide what it's going to do with that guidance as far as who it's going to make loans to and who's eligible.
Right. And I think given it's a finite amount of money made available, folks ought to jump on it before it's all gone, right?
Right. I mean, it's a huge number. It really is huge, but I suspect that probably will, run out at some point.
Absolutely. Okay. Relatedly, so if we're a company that maybe doesn't have institutional investors, maybe they're just small angel investors that are relatively dispersed. In general, are we looking at, I guess, again, looking at that affiliation rule to determine whether or not they qualify, or maybe any sort of key metrics we should keep in mind as a rule of thumb?
Yeah, it will still apply. But when you're talking, angel money, you're generally not talking about there may be angel investors that have their hands in, hundreds of companies that it could possibly be an issue. But, for the most part, you're generally talking about people in just a few small early startups, not many employees. It's pretty likely that even if they are deemed to be affiliated, that when you aggregate all the employees together of everyone that is in the borrower company and everyone that the angel has invested in, because there are generally by definition all startups, are probably not going to aggregate up over this 500 number. So, you probably got more leeway there.
Okay, good to know. Okay, jump into question 4 now, and you hinted at this a moment ago. If I do qualify, or maybe even if I don't qualify just yet, what's my next step? Who do I contact? Am I reaching out to an existing lender, a new lender, an attorney? What's next step?
The first step I'd recommend to any borrower is to reach out to any bank that they have an existing credit relationship with. Every lender I've talked to is basically going to roll this program out when they get rules. You'll hear this many times. We need these regulations in. But as soon as those regulations are in, the SBA lenders are first and foremost going to extend this program out to their existing borrowers, and not just SBA borrowers, more likely even to their conventional borrowers, because what they want to do is be able to shore up their existing loan accounts and their assets on their books. So when they do that, and keep in mind, and don't be intimidated if you don't have an existing SBA loan, because the CARES Act actually provides for the next 6 payments of principal and interest to be paid in full by the SBA for all SBA lenders. So by definition, SBA loans are not going to go into default for the next 6 months, absent something just absolutely ridiculous. So the lenders out there are going to be more worried about their conventional loans, and they're going to want to roll this out first to their current borrowers to make sure they shore up their accounts. Secondly, what they're going to do, SBA traditionally has been a community-based small lending business. And so they're most likely going to reach out to folks in their neighboring communities. We're here in Atlanta, so in the Atlanta area, wherever they're located. So that's something else to keep in mind as you look at national lenders, which we do a lot of work for national lenders. So I don't want to turn anyone away from them, but they're probably going to protect their community first. And then third, they'll open it up to other folks and start taking in new business. And it's going to be in that order too. So time wise, I would advise if you've got an existing banking relationship, I'd reach out to them, particularly if they especially if they have an SBA lending group right now. But even if they don't, because the Act actually provides provisions to include non-SBA participants as long as they're banks and meet certain other criteria. The Treasury and SBA have the authorization to actually expand who can make these PPP loans. So it's worth making that call and asking what they're going to do and what their plans are.
Okay, good advice. Now, if I qualify and apply, typically how long does that process take? And can we go ahead and start the process, or are banks making these loans today?
Well, that's a wonderful question. If it was a traditional SBA loan program, it's a lot longer than most conventional loans, and there's a long lead time. But these are not. So these are intended to be out the door and fast. My lender clients that I've talked to have said that they haven't given an exact timeline, but they are talking about minimal touch in the way of documentation and research and due diligence on these deals. And so it's intended to be very fast in and out. Like we just talked about, because they're intending to go to their customers, existing customers first, they're already going to have a lot of that information. So it's going to be a simplified application, check the boxes, and get the money out.
Good. Yeah, I've heard talk of lenders setting up portals and things like that. So to your point, very low touch. Okay. Now, next question: how much can I borrow? Is this a math equation, or how much can I borrow?
The statute actually includes it's a finite number. It's the maximum of $10 million or 2.5 times your average monthly total payroll. So, and that gets calculated, I think we touched on it earlier, it gets calculated either as a factor of if you ran a business and you had a period back in 2019 that you can compare it to, you can take that expanded period and average it. If you weren't in business back in 2019, you have to take the period of January 1st through February 29th this year and take the average of those 2 months. So, it could be greater, could be lower, depending upon how that works out.
Okay, good. You touched on this one earlier too, question 7. How are the loans under the PPP program excused or forgiven? And knowing that's out there, what are some guardrails we need to be watching out for to make sure that we meet these requirements?
Yeah, well, the key on that is, and this is one of those things where we're going to need the SBA guidelines and regulations to know what they're actually going to ask for. But as best as everyone thinks, this is going to be one of those areas where you're going to submit essentially receipts, kind of like getting reimbursed for your business expenses, and prove that you've used a certain amount of used the loan proceeds as intended. So for example, and I'm rolling here for a moment here as far as the approved uses here. So the approved uses, can be for payroll costs for healthcare benefits, employee salaries, payment of interest on mortgages, but not prepayments, and no principal payments, rents, utilities, interest on other debt from prior to February 15th. And then it also is possible to potentially be able to refinance these economic injury disaster loans in certain circumstances, depending on what they're used for. So that's what you can use the loans for. So when you get into the debt forgiveness, it's actually a little bit different, and borrowers are going to want to keep this in mind, is that when you submit those essentially receipts, you can submit them for payroll costs, interest on payments of covered mortgage obligations, so i.e. interest on mortgages, not prepayments and not principal, payments on covered rent and covered utilities. And those all have defined terms as to the period in which you can submit for, and they have to be for arrangements that were in existence prior to this magic February 15th date. And so you need to match those up very closely. And the idea is going to be that you want to make sure that you have amounts for those payments that are eligible that are at least as much as your borrowed amount, so you don't get left with essentially a loan afterward.
Got it. Okay. Now let's say we successfully make it through the application process and we receive the loan. Does taking the loan impact our ability to subsequently raise outside capital from say a venture fund before the loan is repaid or forgiven?
Another great question. At this point, there's no guidance on that in the actual CARES Act. If it was a traditional SBA loan, it would be a problem. Traditional SBA loans under current SBA guidance is you cannot make changes to your cap table for at least 12 months after the final disbursement of the loan proceeds without SBA consent. And then generally after that, there's it's going to be required lender approval, which is pretty standard in any commercial loan. They don't want you changing your cap table and making massive changes without them at least approving and having a say. But that's a traditional SBA loan. These have absolutely no guidance. So based on what the Act alone says, it's one and done. They shoot you the money, and as long as you use that money for the purposes that are eligible for it being used, there are no restrictions. These are non-recourse loans. There's no guarantees. There's no collateral. So there's no restrictions on changing your entity around.
Great. You just hinted on the next one, question 9, which is, I know, probably near and dear to every founder's heart. As an officer of the company making the application, does anybody in the company need to guarantee these loans personally?
Right. Yeah. As I just said, there are no personal guarantees. Now, that doesn't mean borrowers are completely off the hook. There are certain certifications that are going to be required. They're actually enumerated in the Act. They're all surround about, numbers of employees, but for purposes of determining payroll and for purposes of determining how many employees remain on payroll after taking the loan in connection with getting the debt forgiveness. And then you also have to certify as to their pay levels, because you can't reduce salaries. That's the same as cutting staff. The SBA views it, Congress viewed it the same way. So those certifications are going to be made. So if you, as an officer of the company, and you certify that you gave valid payroll numbers and you use the loan proceeds for the approved purpose, turns out you didn't, there is personal responsibility under the Act. So it's going to come back on you. But as far as guaranteeing in the sense that we have in traditional loans, it's no guarantees.
Perfect. Okay. A couple of questions related to primary uses of the funds. So you've sort of talked throughout about what you can and can't use funds for, particularly related to approved use and as it relates to forgiveness. Would you elaborate on a few of the primary prohibitions on the use of borrowed funds? And then we can talk about a few specific questions as well from clients.
Yeah, so some of the things you can't use them for, and they're listed out there, is you can't use them for compensation for any individual who makes for in excess of $100,000 of annual compensation. So all these numbers for payroll cost calculations, all those cap any individual's total annual compensation at $100,000. Doesn't mean you exclude the person's income. It just means you exclude everything above $100,000. So that's one thing to keep in mind. Certain taxes, withholding taxes, payroll taxes, you can't use these funds to address those. You can't pay employees whose principal residence is outside of the U.S. You can't pay we're thinking this is what the case is, and I'm sort of looking at some summaries that we've prepared and that I've pulled from other sources. We think that certain qualified sick leave wages that have already been compensated and received credit under the Families First Coronavirus Response Act won't be eligible. And that's probably a good thing to keep in mind, is trying to use two programs to do and pay for the same thing is not going to be looked on kindly in any of these federal programs. So, if you're trying to, quote unquote, double dip, that's probably something to stay away from, because that may incur personal liability. And so those are kind of the principal items to think about. You can use them to pay payroll, and you can make compensation, salary, wages, commissions, similar compensation to that. You can make payments for vacation, maternity leave, medical leave, things like that. You can make dismissal payments, separation payments, unfortunate situations like that. If they come up, you can pay for benefits to the extent if you need to, retirement benefits as well. Those are all out there, but some of those may or may not actually be allowed for the loan deferral or so.
Okay.
Deferment, excuse me. So we're going to have to, we really need more guidance on exactly what that is. But in general, this is out there to pay for payroll, keep your business open. And if you do, what one really thinks of, keeping a business open and paying employees, not letting them go, those should be events that are covered and not exposure.
Okay. So related to this, getting into a couple of gray area questions, if we pay independent contractors to maybe handle some of our work, maybe they're overseas, there's certain outsourcing prohibitions in the Act. Are we prohibited from using funds to make those sorts of payments? Arguably, those are quasi-payroll related, although, albeit we're not making them to actual employees, but they are maybe integral to the business. Do we have any guidance on that yet, or what's the?
We don't really have any guidance on that, and particularly if they're located outside the United States, that may be problematic. That is an area we're definitely going to need some guidance from the regs when they come out.
So to the extent we have that, maybe it would be best to allocate other funds to the extent the company has those available to make those sorts of payments. and ensure that we're using, SBA funds to the extent we're submitting receipts and things like that really focused on the true payroll costs.
Yeah, that would be good advice. You don't really want, money is fungible once it goes into an account. So receipts are where the key is. And that probably,
Exactly.
by the time we get to the receipt process, we'll definitely have guidance there. People aren't going to the covered period here is actually from February 15th through the end of June. So there's going to be a period of time, and that's the period where you can submit receipts and be eligible for having this deferments on these, or having, the write-off on the loan, on the debt itself. So debt forgiveness. So by then we will definitely know exactly what is and isn't eligible.
Yeah. At which point we'll know what sorts of receipts to be turning in, right? Okay. Next question, also sort of in a gray area. There's prohibitions on certain distributions, right? Now, putting ourselves maybe in the case of a venture-backed company that is profitable, or an LLC that's profitable, and we're making routine distributions to members, maybe for tax distributions in an LLC taxes partnership, or maybe we've allocated distributions for the prior tax year that have not been made. Do we need to hold on to that cash? Are we prevented from making ordinary course payments to shareholders or members in a company if we take this loan?
Right now, there's nothing in there on that. So, I used the weak expression earlier about, kind of one and done. On that front, it looks like, your borrowers will get their money and they can run their business like they want. They're going to want to only use, if they're documenting that they're using, if they took the loan and immediately declare a dividend exactly the amount of the loan, that probably would look bad. But if they're, running a profitable business and they just continue to make ordinary course, distributions like you suggest, then who's to say if that money came from ordinary operations or from the PPP program?
Again, it's probably one of those items that'll turn on you just wouldn't be returning those types of receipts, right? At the end of the day, right? Okay.
Yeah. Now, those aren't going to be eligible for, to get, your loan forgiveness. But, certain of those costs, certain of those payroll, to some extent, and once again, we're getting a tax, which is outside my area. I'm not even going to pretend to know that. But, some of these, distributions could actually be deemed to be payroll, particularly in like a single member LLC or something like that. So, that might be something that could be eligible. That's when we're, if you want the specifics on that, talk to your tax advisor.
Perfect. Okay. All right, Richard, but that's all the questions we had submitted by founders. Really appreciate you taking the time to educate us all on this.
You're welcome. Good luck all.
Thanks, guys.